Welcome to Public Civics. This is a series presented as a public service. I am Dr. James Griffith, and I'm here today with Professor Dwight Duncan, who is a professor and a scholar in constitutional law at the UMass Law School. We're trying to make the complexities of our town and nation more clear to our citizens in the hope of the best government we can have. We are focusing on the highest law of our land, the Constitution. Welcome, Professor Duncan.
Great to be here.
The U.S. Constitution was written during the summer of 1787 in Philadelphia by 55 delegates to a constitutional convention. Why does it matter 238 years later?
Well, what they came up with, even though their proceedings were all in secret, they basically gave birth on September 17th and issued to the public the draft of their proposed constitution, which was within 2 years enacted by the requisite number of states, 9 out of the 13 original, and eventually they all ratified it, so that it went into effect in 1789 with the first government, with George Washington as our first president, the first Congress meeting. It established the framework of our government, and it's the oldest written constitution in the world. This business of writing a written constitution to establish the framework of government was a fairly new phenomenon worldwide and in world history. So the amazing thing about our U.S. Constitution is we still have the basic Constitution. Admittedly, there are 20-some amendments, 10 of which occurred within 2 years of the establishment of the first government. So in 1791, the so-called Bill of Rights, the first 10 amendments to the Constitution. But so it's been amended rather rarely in our history, and it's rather difficult to amend. But the point is, it's worked. It wasn't perfect. I don't think anything is really perfect in a way in this world, but it's worked for us. And one of the interesting things about being an American is, unlike a lot of other countries, we don't necessarily share an ethnic identity or a kind of a racial profile. We're a mix, and we've always been a nation of immigrants. The one thing we have in common is not really our ethnic origins, our religion. You know, we have a lot of different religions, obviously. What we do have in common, though, as Americans, is our framework of government and our rights as citizens of the United States, right? So this is the one unifying thing in the United States, really. And so it seems to me it's very important in a way that people understand this. And just realizing what it is that makes us Americans, what is it that's distinctive about this country from the get-go, and what is it that makes it so attractive to immigrants, both legal and illegal? You know, why do people want to come here and move here? And I think a lot of it has to do with our system of government and our tradition of rights and kind of due process, rule of law. All of that, which it's not shared by the rest of the world necessarily. I'm a big fan of our Constitution. Of course, that's in my selfish interest because I teach constitutional law, but I'm a big fan of the Constitution with its flaws and all. One of the problems at the origin was, of course, they tried to finesse the issue of slavery, and they basically never used the word slavery in the Constitution, but in various ways it was recognized, and that was a price really of getting a constitution, because the South clearly was not going to join the abolitionists, right? Even if some of the North were in favor of it. People like John Adams and Alexander Hamilton were, they were on the free side of the ledger, right? But so in some ways, no, the original sin was slavery, and eventually this was rectified. It was rectified by the Civil War, on the battlefields ultimately, but then the results of the Civil War were enacted into the Constitution with the 13th, 14th, and 15th Amendments, abolishing slavery, establishing birth citizenship, right, and due process and equal protection of the law. So, and in the 15th Amendment, a right to vote irrespective of race, which sadly was largely a dead letter in the Constitution for, the better part of a century, really until the 1950s and in the 60s, and with the passage ultimately of the Voting Rights Act of 1965, that it first began to enforce that.
It is said that the Constitution was the product of political compromise after long and rancorous debates over issues such as states' rights, representation, slavery. Delegates from small and large states disagreed over whether the number of representatives in the new federal legislature should be the same for each state, as was the case under the Articles of Confederation, which I think preceded the Constitution,
It did.
or different depending on a state's population. There was a New Jersey plan, there was a Virginia plan. In addition, some delegates from northern states sought to abolish slavery or, failing that, to make representation dependent on the size of a state's free population. Were all of these and other issues unanimously settled?
Well, like I say, with respect to the slavery issue, that was just shelved in a way, that they reached a kind of workable compromise whereby, sadly, slave population counted for 3/5 in terms of apportionment. Houses, representatives in the U.S. Congress, which basically gave the slave states a disproportionate influence in the federal legislature. On the issue of proportional representation versus state representation, there was a compromise on that too, in the sense that we decided to have a bicameral legislature, two houses. The House of Representatives would be apportioned on the basis of population, and so a higher population would give you a stronger influence, obviously, but the upper house, the Senate, was apportioned on the basis of, two for each state, regardless of whether you were a large state like New York or a tiny state like Rhode Island. And so in order to pass laws, you needed both houses really to concur. So in some ways, that was a compromise, but it's largely worked in our history.
In 1788, in an effort to persuade New York to ratify the Constitution, Alexander Hamilton, John Jay, and James Madison published a series of essays on the Constitution and Republican government in New York newspapers. Their work was written under the pseudonym Publius and collected and published in book form as The Federalist, which was published in 1788. Do the Federalist Papers have any continuing meaning today?
Well, they do, because it was the argument for the U.S. Constitution, for the states to ratify it, and in some states it was pretty a close call, like New York or even Virginia. It was a close call, but largely on the basis of the arguments propounded in the Federalist Papers, mainly written by Alexander Hamilton, but also James Madison wrote a number of them, and John Jay wrote one or two as well. So on the basis of that, it was ratified, and so in terms of the original understanding of what the Constitution meant, the Federalist Papers are fairly authoritative.
Why were the Bill of Rights, the first 10 amendments to the Constitution, not added until December 15th, 1791?
Well, they weren't added because the original Constitution as written in Philadelphia in the summer of 1787 did not contain a Bill of Rights, but a number of states in ratifying the Constitution expressed their dissatisfaction with this and asked for a Bill of Rights, so that one of the first things the first Congress did, and this was largely the work of James Madison, who's considered more than anyone the father of the Constitution. Originally, the position of the Federalist Papers was that a Bill of Rights was unnecessary because the federal government was not given powers to, for example, regulate religion or free speech or the press. and therefore it was unnecessary, since the federal government had no express powers over those subjects, that somehow people's rights were implicitly understood. But I think there was a fair amount of nervousness about giving the federal government not just the explicit powers that it has spelled out in the Constitution, but through what's called the Necessary and Proper Clause in Article 1, Section 8, as among the powers of Congress, Congress can enact legislation that is considered necessary and proper to effectuate the powers of government. The fear was that this implicit power of the federal government could invade things like religion, freedom of religion, or freedom of speech or of the press. I think that's a serious, serious concern, right? So the fact that the First Amendment begins by saying that Congress shall make no law respecting an establishment of religion, so there's no official religion or church in this country, unlike in England, which we had recently broken away from, or unlike most countries in history up until that point. We were sort of anomalous in recognizing freedom of religion. So I don't know. I mean, I'm a big fan of the Bill of Rights, and one of the other concerns I think that the Federalists raised about a Bill of Rights was that if they tried to spell out in particular, in detail, what the rights were, that if they failed to mention them, they would be surrendered and not recognized. And they tried to cover that eventuality in the 9th and 10th Amendments to the Bill of Rights, which basically said that powers not granted to the federal government are reserved to the states respectively or to the people, right? And more or less, you can't argue from silence in the Constitution that a right does not exist, that there's room for implied rights.
In the preamble, it states, in part, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and to our posterity, do ordain and establish this Constitution of the United States of America." What do we miss when we skip over the preamble?
Well, the preamble basically says why it is that they're writing a Constitution, right? The purpose of it. And so I think this is important because obviously the intention and the purpose of something, governs should govern its interpretation, right? On the other hand, though, it's in order to, that is, it's a purpose. And the actual operative language of the Constitution is what follows in the various articles, right? Where it's spelled out in detail what the governing law is. So I guess what I'm saying is it isn't operative in a legal sense, I don't think, right? But I think it should guide interpretation and enforcement of the Constitution, right? These are the reasons why, to ensure domestic tranquility, this is reasons why, Congress has the power to regulate commerce among the several states or to declare war even, right? That are spelled out in the Constitution.
Has that guidance been in evidence subsequently in actions of the United States Congress or the Supreme Court or the President? Has that guidance from the preamble?
I think yes, indirectly. And obviously it varies from time to time and from what entity we're talking about, in terms of whether they pay much attention to the preamble. But I do think it's important for one thing, I think it's important to interpret the Constitution in light of the Declaration of Independence, right? Which I think isn't always done. The Declaration of Independence talks about certain self-evident rights, right? Among them life, liberty, and the pursuit of happiness. That was a sort of an interesting change that Jefferson made to the traditional property, right? But it's an interesting gloss.
Article 1 vests all legislative powers in the Congress, the House of Representatives, and the Senate. The Great Compromise stipulated that representation in the House would be based on population, and each state is entitled to 2 senators. Members of the House serve terms of 2 years, senators serve terms of 6. Among the powers delegated to the Congress are the right to levy taxes, borrow money, regulate interstate commerce, provide for military forces, declare war, and determine member seating and rules of procedure. The House initiates impeachment proceedings and the Senate adjudicates them. Would a parliamentary system be superior to this?
I don't think so, but I'm not really an expert on parliamentary systems because we don't have one. I mean, Britain has one, France has one, I think, a number of other democracies, have them, but our system has worked for us. I don't know what else to say about that.
Article 2 vests executive power in the office of the Presidency of the United States. The president is elected by an electoral college to serve a 4-year term, is given responsibilities common to chief executives, including serving as the commander-in-chief of the armed forces, negotiating treaties, 2/3 of the Senate has to concur, and granting pardons. The president's vast appointment powers, I think currently the United States president coming into office appoints in the range of 4,000 executive employees, which include members of the judiciary, the cabinet, subject to the advice and consent. Originally, presidents were eligible for continual re-election, but the 22nd Amendment in 1951 later prohibited any person from being elected president more than twice. Although the formal powers of the president are constitutionally quite limited and vague in comparison to those of the Congress, a variety of historical and technological factors such as centralization of power in the executive branch during war and the advent of television have increased the informal responsibilities of the office extensively to embrace other aspects of political leadership, including proposing legislation in Congress. Are we now in a period of questioning presidential powers?
I think there's no question, but in the 20th century and even more recently, the powers of the president have increased dramatically. Partly it was due to World War I and World War II, were obviously very, very important in terms of just the growth of the federal government and particularly the executive branch. And I don't know, the Pentagon was established, in the middle of World War II, right? The powers of the president have increased. And of course, we were founded with a pretty significant distrust of executive power. That is to say, the American Revolution, I think one has to understand it as a reaction against George III and basically a monarchical system. So that in part explains why it was that the original national government, the federal government, was the Articles of Confederation, in which there was only a national legislature, but there was no national executive nor general judiciary, federal judiciary. The feeling was that didn't really work. We needed a significant executive to unify the country. And fortunately, we had in George Washington the perfect role model for a president. Among other things, well, he had led us through the American Revolution. He chaired the Constitutional Convention in 1787. And then he was a great first president. He was a person who had tremendous self-control and self-restraint. But it was a great model. And the other thing is he voluntarily stepped away. Just as he voluntarily resigned his commission as the head of the Continental Army, he also refused to run again for president. So was succeeded by John Adams, who had been his vice president. And it's very rare, if you just look at history, it's extremely rare for somebody in power to voluntarily relinquish it. But Washington did, to his credit.
And here it was happening in a brand new country.
That's right, yeah. No, I mean, he could easily have been dictator for life.
Yeah.
And people, because of his character, I think people would have rightly trusted him, but it would have been a bad precedent, So, and in fact, him serving only 2 terms was really the unwritten rule in presidencies until Franklin Roosevelt, in 1940 with the onset of World War II, where he broke that tradition. And then, of course, shortly thereafter, the 22nd Amendment was enacted saying that two terms is the limit for presidents. And I think that's right. I mean, I would kind of wish we had term limits, not just for presidents, but also for legislators and, for that matter, judges. It's going to be difficult to get those term limits because of vested interests, A, and B, probably you'd have to amend the Constitution. And the one defect that I would point to in the U.S. Constitution is that it's extremely difficult to amend. And I think, unfortunately, this puts a lot of pressure on the courts to engage in pretty creative constitutional interpretation to, in effect, amend the Constitution through interpretation, which I don't think is really the way it should work. But I think that's the way it has worked in a lot of ways. I just think it's an interesting structural issue in the Constitution.
Article 3 places judicial power in the hands of the courts. The Constitution is interpreted by the courts. The Supreme Court of the United States is the final court of appeal from the state and lower federal courts. The power of American courts to rule on the constitutionality of laws is known as judicial review, is held by few other courts in the world, and is not explicitly granted in the Constitution. The principle of judicial review, first asserted by Supreme Court Justice John Marshall, Marbury versus Madison, 1803, when the court ruled that it had the authority to void national or state laws. Beyond the body of judicial rulings interpreting it, the Constitution acquires meaning in a broader sense at the hands of all who use it. Congress, on innumerable occasions, has given new scope to the document through statutes, such as those creating executive departments, the federal courts, territories, and states, controlling succession to the presidency and setting up the executive budget system. By what means do the courts enforce their rulings?
The courts can issue orders or decrees, by way of injunctions. But the problem is the courts do not have the power of the purse strings. They can't fund anything. That power is granted to Congress, right? Congress has to originate revenue-raising measures, so they can't kind of buy the enforcement. And I suppose the other thing is, unlike the president, they don't have a military and and police force at their disposal. So really, Supreme Court and the courts, I think they require the cooperation of the other branches, right, in terms of being effective, and because they don't have the money which Congress controls, and they don't have the military, which the president controls.
I've read some people consider the judicial system the least equal of the 3 equal branches.
Yeah.
Fair or not?
Yes, except that in terms of interpreting the Constitution and the laws, the Supreme Court is the last word on that subject. So that's an incredible power, really, and responsibility as well, I think. And you mentioned judicial review and originating in Marbury versus Madison and Chief Justice Marshall's famous opinion. But judicial review, sometimes it's worked really well. Like, for example, I would point to Brown versus Board of Education in 1954, where the Supreme Court somewhat courageously but unanimously decided that segregation in the public schools violated equal protection of the laws. And I think that was a home run from my perspective in terms of judicial review, because 10 years later, the U.S. Congress, when Lyndon Johnson was president, enacted the Civil Rights Act of 1964 and then the Voting Rights Act of 1965, which in effect which represented popular ratification of the court's Brown decision 10 years earlier, even though there had been a lot of turmoil in the interim, right? So to me, that's a wonderful example of judicial review. The problem is there are other examples in our history where judicial review turned out badly. And specifically, I would point to the Dred Scott decision from 1857, where the court ruled that Congress and the federal government had no ability to outlaw slavery in the federal territories. And it sort of entrenched slavery in a way that ultimately led to the Civil War.
Article 4 deals in part with relations between the states and privileges of the citizens of the states. These provisions include the full faith and credit clause, which requires states to recognize the official acts and judicial proceedings of other states, the requirement that each state provide citizens from other states with all the privileges and immunities afforded by citizens of that state, and the guarantee of a Republican form, small r, Republican form of government in each state. Does any of this still matter today?
Yes, in the sense that like the Privileged Immunities Clause under Article 4 prevents states from discriminating against out-of-staters with respect to privilege. Whatever privileged immunities they grant their own citizens, they have to give to people who are not visiting from out of state or whatever. So yes, it's still important. Full faith and credit clause is important. I mean, that means, for example, that if you're legally married anywhere in the United States, you're legally married everywhere, right? That's an illustration of the force of the full faith and credit clause. So yeah, it's still valid and operative.
Article 5 stipulates the procedures for amending the Constitution. Amendments may be proposed by a 2/3 vote of both houses of Congress or by a convention called by Congress on the application of legislatures of 2/3 of the states. Proposed amendments must be ratified by 3/4 of the state legislatures or by conventions in as many states, depending on the decision of Congress. All subsequent amendments have been proposed by Congress, and all but one, the 21st, 1933, which repealed prohibition, the 18th Amendment, 1919, have been ratified by state legislatures. Are we in need of additional amendments to the U.S. Constitution at this time?
That's a good question. And I'm going to punt on it because there have been recently calls for a constitutional convention. We have not tried to amend the Constitution by the Constitutional Convention method that is spelled out in Article 5. We've never done it. And the fear is, at least from people like me, the fear is that a Constitutional Convention would essentially do what the original Constitutional Convention did, which was they were supposed to only amend the Articles of Federation. Instead, They decided this is hopeless. We're going to rewrite. We're going to start all over again. So the fear is that essentially a new Constitutional Convention would totally rewrite the Constitution. I think there's a lot of concern about what would come out, right? This is where our Constitution, for all its defects and limitations, has served us well for our 250-year history. It's not too clear that if we started from scratch and came up with something new, it would be any better, right? And there have been hundreds and hundreds and hundreds of federal constitutional amendments proposed through our history, but less than 30 have been enacted. The chances are very unlikely of amending the Constitution.
Is what you're saying an example of amending the Constitution is difficult, but not too difficult? Because we have amended it, but we don't amend it very often. Does that mean that the Founding Fathers, 238 years ago, hit the nail on the head?
The question is whether they made it too difficult. My sense is that in effect it was too difficult. But people can argue about that. I think there is a certain stability that's involved, right? In not being able to amend it too easily. But nonetheless, some amendments have gone through. The most amazing episode is the one you alluded to. It's that in the span of 13 or 14 years, there were two constitutional amendments on the subject of prohibition that were the exact opposite of each other, enacted by supermajorities, which are required, right? So that's an amazing thing in our history, right? It's like prohibition had that popular appeal that it was enacted in the first place, and then the Volstead Act enforced it at the federal level. But the experience with prohibition was not a good experience. Organized crime got a huge boost, through prohibition. And the other thing that happened is the number of speakeasies in New York. We're talking about thousands and thousands of speakeasies, so which were illegal. So average citizens got in the habit of law breaking in prohibition, which was also a kind of a bad thing, right? It's always bad, it seems to me, when the laws are out of kilter with what people are actually doing. A current example of this, I think, is the whole immigration question. I think there's real need for legislative reform in this area. My own sense is that both parties are much more interested in pandering to their base and adopting extreme positions on immigration and therefore unwilling to compromise in the least in order to get effective reform accomplished. And I think this is one of the problems now, I think, in our legislatures. It's that they're dysfunctional in a lot of ways. They shy away from anything that has any controversy, and so they're not effective, right, in terms of coming up with workable rules, right, to govern this mess. And I don't think that's a good situation from a lot of perspectives.
Article 6, in which prohibits religious tests for office holders, also deals with public debts and the supremacy of the Constitution, citing the documents as the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. How supreme is the Constitution in our day?
It is supreme. The Constitution and laws that are consistent with the federal laws consistent with the Constitution are the supreme law of the land. Anything to the contrary in state and local laws notwithstanding, I would say that the supremacy clause is effective, right? That's the rule. One of the provisions that you mentioned in Article 6 is the religious test provision, right? The original Constitution didn't have a guarantee of freedom of religion, but they did have this statement that there should be no religious test for public office in the federal government, right? Which was a very significant move, right? Because this was a tremendous departure from English practice, but not just English practice. Pretty much the world had not, religious tests were quite frequent in government. So it was a huge step in the right direction, in my view.
Article 7 stipulates that the Constitution would become operational after being ratified by 9 states. Is the Constitution still amended by the will of only 9 states, or 3/4 of 50?
Well, no, you need 3/4 of the 50 states now. 3/4 of the original 13 was 9, and that's why they had that as the initial.
There are various issues dealt with in the Constitution. One of them is powers. The national government has only those constitutional powers that are delegated to it, either expressly or by implication. The states, unless otherwise restricted, possess all the remaining powers, according to the 10th Amendment. Thus, national powers are enumerated, Article 1, Section 8, and state powers are not, 18th Amendment. What is the practical meaning of reserved or residual powers today?
Well, it depends on what the courts decide fall within federal authority, because if the courts decide that a given power is delegated to the federal government, then there's no reserved state rights on that subject. So as a practical matter, it depends on what the courts decide, really, I think.
Another arena that's dealt with in various places in the Constitution are states' rights. Competing concepts of federal supremacy and states' rights were brought into sharp relief in questions about the commercial regulation. The Commerce Clause simply authorizes Congress to regulate commerce with foreign nations and among the several states and with the Indian tribes, particularly since a series of decisions in 1937, the court has interpreted Congress's regulatory power broadly under the Commerce Clause as new methods of interstate transportation and communication have come into use. Can the states regulate interstate commerce, including cryptocurrency?
They can regulate commerce that involves other states. The problem is there's a doctrine called the Dormant Commerce Clause, which the Supreme Court has articulated over the centuries, really, which puts limits on the abilities of states to discriminate against out-of-state buyers, sellers, traders, what have you, manufacturers. Yes, they can regulate it, but they have to not run afoul of this non-discrimination against out-of-staters with respect to commerce.
So now that we're in the internet and e-commerce world,
Right.
And there are players like gaming platforms and all of that kind of thing where you don't even know where these entities come from. How would Congress go about, without violating the clause that you just mentioned, how would Congress go about regulating any of that?
The internet and all these things are either in interstate commerce or certainly affect interstate commerce. Congress does have the power to regulate those things, right? The internet, gaming, social media, and particularly things like age verification requirements for social media. Congress would have the ability to do that. Whether they would do it or not is a different question. And if they don't do it, it seems to me there's an opening for states to do it, to try to do it, right? For example, to impose age verification laws for social media. The Supreme Court just recently upheld one such attempt by a state to regulate that, right?
Civil liberties. The federal government is obliged by many constitutional provisions to respect the individual citizen's basic rights. Some civil liberties were specified in the original document, notably the provisions guaranteeing the writ of habeas corpus, trial by jury in criminal cases, that's Article 3, and forbidding bills of attainder and ex post facto laws, Article 1. But the most significant limitations to the government's power over the individual were added in 1791 in the Bill of Rights. The Constitution's First Amendment guarantees the right of conscience, such as freedom of religion, speech, and the press, and the right of peaceful assembly and petition. Are civil liberties in need of further protection today?
My own sense of it is that the First Amendment goes quite far, and I'm for a fairly broad, generous reading of the First Amendment, both freedom of religion and freedom of speech and of the press. And so I think if properly interpreted, by the Supreme Court, I'm not sure what else we need, but at least for those rights, there can be issues. Well, I don't know. Obviously, the courts are fallible, and they could come up with, not helpful interpretations, or come up with very narrow readings of these freedoms that we have. And I think that in that case, it should be addressed through legislation. The main thing that I think is important is it's important that the public understand their rights and educate themselves about our system of government and how they can, try to vindicate their rights. Because otherwise, the Constitution and laws they're just words on paper. They don't automatically translate into practical reality. But one of the good things about our Anglo-American legal tradition is we've had a fairly realistic understanding of rights, whereby a right, if it's just theoretical, it doesn't mean a damn thing. It has to be, you have to be able to enforce it and put it into practice. But I think a lot of that depends upon, people being vigilant, right? About their rights and recognizing when it is that government is crossing the line. The framework is pretty good in terms of being able to raise these issues, and a lot of modern countries are overriding freedom of speech in a way that is shocking to an American, rightly so.
After the Civil War, 3 new constitutional amendments were adopted. The 13th, 1865, which abolished slavery. The 14th, 1868, which granted citizenship to those who had been enslaved. And the 15th, 1870, which guaranteed formerly enslaved men the right to vote. The 14th placed an important federal limitation on the states by forbidding them to deny any person life, liberty, or property without due process of law, and guaranteeing every person within a state's jurisdiction the equal protection of its laws. Later interpretations by the Supreme Court in the 20th century gave these 2 clauses added significance. Gitlow versus New York, 1925, the Due Process Clause was interpreted by the Supreme Court to broaden the availability of the Bill of Rights protection of speech to the states holding both levels of government to the same constitutional standards. Is due process a settled matter? If not, why does it matter 238 years later?
I don't think it's ever settled in the sense of once and for all. There's this whole controversy, which you really didn't go to, about so-called substantive due process, the idea that certain rights that are not expressly stated in the Constitution are in effect read into the Constitution. The most notable example of it, I think it's a good example of substantive due process, is in the 1920s, in a couple of decisions, the Supreme Court said that there's a fundamental right that parents have to direct the upbringing and education of their children. And that's nowhere expressly stated in the Constitution, but I think it's a great right, actually. It's a good, and it was unanimous when the court adopted it, and it's been accepted, and applied ever since for 100 years. The idea of due process, though, is extremely important. I suppose one of the other things that I would point to that's interesting in the 14th Amendment, it doesn't say a citizen shall not be deprived of life, liberty, or property. It says a person. And the reason was, it was intended, among other things, to reverse Dred Scott, which Dred Scott, the decision didn't deny that he was a person. It said he wasn't a citizen and therefore he had no rights. Yeah. So what I'm saying is, it's interesting that these rights don't necessarily require citizenship, right? Some rights do, like maybe voting or whatever, but I'm saying that's a different thing. But basic rights, basic fundamental rights, the life, liberty, and property shouldn't depend on citizenship.
I would like to thank Professor Duncan very much, and I thank all of you for tuning in and listening. Our hope is that you talk with your neighbors about the U.S. Constitution and all the other topics that we have on this platform. You will be a more informed citizen, and Dartmouth will be the better for it. This has been a public service presented by the Dartmouth Democratic Town Committee and Dartmouth Community TV. Our intention is to provide a thoughtful discussion of matters that affect our lives in Dartmouth and our responsibilities as citizens. For questions, please contact Dartmouth Dems, no punctuation, @outlook.com. And once again, thank you all for paying attention, and thank you, Professor Duncan, for a reading and an interpretation of a document that means so much to all of us. Thank you very much.
Thank you.